In no surprise to anyone, Lively's counsel have filed another motion for fees and sanctions. This time, they're doing so under the California statute 47.1, a new law in California that says that statements, communication related to someone's own experience of sexual harassment or assault cannot form the basis of a defamation claim. They're saying that because the lawsuit that the Wayfarer parties had against Lively and Reynolds and Sloan and New York Times was dismissed, they therefore should be entitled to all these damages available under California law pursuant to this statute. Now, let me tell you my first gut reaction before getting into the weeds of this. There is very little chance that this judge is going to A, rule on this now before there's a trial, or B, rule on this at all, because this is a issue of first impression, meaning there's no case law on this, no California case law, no federal case law, no case law. So a judge that is being presented an issue that is squarely state law is not going to want to be the first judge to decide on it, especially if they don't have to. And that was proven to me by his 132-page order to dismiss that came out in June, dismissing the Wayfarer suit, that didn't touch 47.1. It did not form the basis for why Wayfarer's claims were dismissed from this lawsuit. The judge didn't look at any of the amicus briefs that were filed. Remember, there was like 13 of them or some absurd number. Didn't touch any of that, didn't discuss any of that, didn't go into the legislative history of 47.1. It didn't come in at all. He found other reasons why he thought that it was appropriate to dismiss Wayfarer's claims at the time and did so. He did leave a window open for Lively to come back and file a motion like this, which is why we're seeing it here today. But as a general matter, even if this wasn't 47.1, even if this was just looking for attorneys' fees, let's just say there was some other statute or fees, this is not something that a judge typically rules on before there's a trial, in the middle of things. It's just not something that they typically would want to rule on, especially if it has massive numbers involved. Instead, they would allow for the trial to happen. They would continue this hearing related to this until after the trial, after everything's over, and then would consider all fee motions together before deciding on something like this. I just don't see him ruling on this now, which is why the Lively party has specifically asked for a hearing or an evidentiary hearing right away. They want this dealt with right away. And I don't think that the judge is going to do that. So, as a reminder, Section 47.1 says that communication related to harassment, someone's own experience of harassment, cannot be, that is said without malice, cannot be the basis for a defamation claim. And they have a legal problem here, which you can see in footnote 11, because the judge, while he says that Reynolds, Sloan, and New York Times did not act with malice, the judge didn't extend that to Lively specifically. So they're asking the judge to stretch that order to include Lively, such that they can say that you ruled she didn't say these things with malice. Therefore, we are entitled to these damages that the statute allows. That's a stretch. And I think that's going to be hard for them to overcome. The rest of this filing is like a legal hit piece. They have thrown everything and anything negative about the Wayfarer parties or their counsel into this motion, including a history of all the times that they've sought sanctions and all the bad things that they think that the other side has done or said. They've thrown it all, jam-packed it into this 30-page filing. And then they add this mystery declarant, this mystery witness that says that they were verbally abused by Baldoni and testifies under oath, even though they're a mystery person, that Baldoni was not allowed on this set of this other project. Don't even know what this other project is. But this is so disconnected and unrelated to the inquiry here that they have to know the judge is not going to consider this as evidence to support whether or not to give damages related to the protected privileged communication, because it's not related to it, but they're throwing this in there to say, see, and somebody else thought he was a bad guy too. There's some speculation about who that might be. I don't think it was an actor or actress on the set of this movie. I don't think it was even somebody who worked at Wayfarer. Could be, I don't know. My best guess is that it's somebody that worked maybe for the agencies or the distribution agencies or the marketing companies, sort of peripheral person, Sony, WME, something like that, that may have been involved in other projects. It doesn't sound like someone that was really embedded. They don't come out and say, I was also harassed. They're saying, I had some negative interactions with him. But who cares? That's not what's going to get them damages under 47.1. 47.1 is about protected speech. Protected speech of Lively, not even protected speech of Reynolds or Sloan or New York Times. All of that comes out of the equation. It's really just her speech. That's it. The only other interesting thing in this whole filing is that they seek treble damages. Treble damages are super rare. They are usually not connected to defamation cases unless there's some statutory violation. So you might see it in RICO or consumer-related actions, not in defamation cases. But anyway, they're asking for it. But what I find was interesting is that they are saying that the full extent of the harm that she's suffered is being figured out by experts right now, which is contradictory to what she has stipulated to narrowing her damages to garden variety emotional distress. Remember way back when she didn't want to turn over her therapy notes and doctor's information and all that stuff that you would typically use to prove that you've been severely emotionally distressed or psychologically damaged. She said, I'm not turning that over. So there was an agreement then that she would only seek garden variety and not seek special, specific, huge numbers. So for them to come here and now say, experts are going to say just how bad this has psychologically stressed her out, I find that inconsistent with the position that she's holding in this case about her emotional distress. So I don't know how they think they're getting away with that. Remember the Rule 11 motions filed back in May, the Rule 3.6 motion for sanctions against Friedman, and now this motion. I just don't think the judge is going to touch this. He hasn't, and he probably won't until he has to, and that's probably after trial. So this was an act of kicking up dust to remind the public of just how terrible, awful, horrible the defendants in this case allegedly are.